2013 was amended in 2020 by the Amendment Act of 2020. And we had to wait for 3 years for this particular amendment to come into force. The amendment was the addition of 2 new subsections in Section 23, that is subsection 3 and subsection 4. Now, this was made effective in the month of October. That is, I think, 30th of October, they came into force. And now, after a gap of 4 months, MC has come out with the rules. Understandably, because simultaneously, the changes were to be made in the rules, in the FEMA rules, under FEMA, that is the non-convertible securities rules. Now, to discuss all these matters, our experts will go into details of these matters. And then in insolvency law, there are very important changes in the liquidation, in the regulations governing insolvency process for personal guarantors, for corporate debtors, etc. Now, in today's webinar, our experts will take us through the update and also tell us what are the opportunities arising out of it and what is the impact of these changes on business and the companies, what are the implications. Friends, we have a very distinguished panel of speakers who are all very well known to you. They are specialists. We have with us Mr. Amit Gupta, a very well-known practicing company secretary and insolvency professional. In fact, the leading practicing company secretary in Lucknow. He is a seasoned professional and has hands-on experience, particularly in company law, securities law, and in insolvency law. We have with us Mr. Ankit Singhi. He is Head Corporate Affairs and Compliance Corporate Professionals. He is so well known to us for his expertise in compliance management and his deep understanding of the implications of company law, FEMA, of course, his expertise in corporate governance and now ESG. Perhaps I would like to share with you that he is also an accomplished author and a writer, having to his credit several books and a very large number of articles, which gives us insights into the various intricacies of these complex subjects. I extend a very warm welcome to you, Amit ji and Mr. Ankit Singhi. I'm sure our participants will benefit out of your expertise. Friends, before I hand over to our experts to take us through the regulatory updates, let me tell you that our journey of knowledge sharing, which started in April 2020, will continue. And our next webinar will be held on 15th of March, because 8th March is Shivratri, is a holiday, public holiday. So we will have our next webinar on 15th of February from 4 p.m. to 6 p.m. And for this webinar, we have selected a very important topic, that is human resource restructuring in the light of new labor codes. In my personal view, this is the time is most opportune for us to plan our HR restructuring, because I'm sure after the new government takes over, after the parliament election, this will be a priority of the new government to enforce the new labor codes. Friends, without taking much of your valuable time, may I now request, I think we will structure it like this. I'll request Mr. Ankit Singhi to take us through the updates in company law and LODR, followed by Mr. Amit Gupta ji will take us through updates in insolvency law. Over to you, Ankit ji.
Thank you, sir, and good evening, everyone. So we will be discussing some of the key changes that have taken since I think last couple of months, starting from January. So Shivam, you can move. So first of the significant amendment, I think, is something which the Indian Inc. and specifically startups and other companies were looking for long, where they will be allowed to list in foreign jurisdiction without mandating them to first list in India. So, under the Companies Act, Section 23, subsection 3 and 4, there were provisions which enabled an Indian company to even list in foreign jurisdictions, in foreign exchanges, apart from the Indian exchanges like BSE and NSE. But those provisions were not notified, and there were a lot of deliberation that were going within the various departments of government of India. And for last many, I think, year, we were listening that their norms will be coming out, and some things are being under discussion among the tax department and other. But and then finally on 30th October last year, the subsection 3 and subsection 4 were notified by the ministry, and thereby paving the way that the enabling provisions were notified, by which an Indian company can list its shares directly on a foreign exchange. Then after 30th October 2023, nothing moved, and until January 24th, 2024, where the ministry finally notified the company's listing of equity shares in permissible jurisdiction rules 2024, and simultaneously also amended the FEMA non-debt instrument rules 2019. In addition to both the amendments, the government also issued a set of FAQs, whereby clarifying various issues connected with the listing of the shares of Indian companies in some such permissible jurisdiction. So I think what is important, first of all, is to note what is permissible jurisdiction. So permissible jurisdiction is the jurisdiction that the government will notify from time to time. And to start with, the government has notified the international exchanges at Gift City. There are two exchanges at this point of time in the Gift City. Both the exchanges have been notified as the jurisdiction for the purpose of listing of equity shares under these rules. One may say that Gift City is based out of India, it's in Gujarat. So how it can be a foreign jurisdiction for one to list its shares? So Gift City for all purposes is treated as a foreign jurisdiction. And even if you see under the ODI rules, where Indian residents are allowed to list their shares on Gift City, they can list their share, they can invest in Gift City. They have to follow the ODI rules. But since the Indian companies are which are already registered in the domestic tariff area of the country, apart from the Gift City, the other jurisdiction, therefore these companies, when they would be listing their shares in the jurisdiction of Gift City, it would be treated as a permissible jurisdiction, which is outside, in a way, outside India. And but for the purposes of, since it's an Indian company where the shares are issued in India otherwise already, and they are listing their shares in the exchanges notified under the Gift City, under the amendments which are proposed in FEMA non-debt instrument rules, such investment will be treated as a foreign investment and will have to be in accordance with the sectoral cap and other guidelines which are mentioned therein under the respective schedule under the FDI rules of 2019. So if you want to issue shares, for example, in a share in a sector which is where in foreign investment is allowed under government route, then you can only list your shares in the jurisdictional exchanges in Gift City if you have obtained the prior approval of central government for the purpose of receiving those foreign investment. Can you move to next slide? So the rules which have been issued under the Companies Act, three types of eligible entities and individuals are covered. One is a listed entity whose shares are already listed in recognized stock exchanges in India. Other is an unlisted company, and other are the shareholders of either of these companies. So the shareholders of either of the companies can also list the share by way of offer for sale on the permitted jurisdiction in stock exchanges, while the listed entities will have to wait for the regulations from SEBI for the purpose of identifying the regulatory framework to list their shares in the gift city. The provisions have to be notified by SEBI. For the unlisted companies, they have to comply with these provisions, which are under the rules issued under the Companies Act. Predominantly, it outlines the eligibility criteria, that what class of companies are eligible. Unlisted companies are eligible to issue their shares or list their shares on the gift city stock exchanges. And then it also provides a schedule and a form of prospectus which has to be filed with the registrar of companies in a similar fashion. When an Indian companies list their shares on BSE and SE, they file their prospectus on the with the registrar of companies. Similarly, these companies will, when they decide to list on an international stock exchange, they have to also file their form leaf 1 with the registrar of the companies, and the disclosure that are required are given in schedule 1 as schedule to the rules. It is important to note that the international the IFSI issue and listing of securities regulation 2021 would be the predominant regulations that one need to comply when they intend to list on a exchanges on the gift city. Apart from the eligibility criteria prescribed under these rules, those regulations also outline these eligibilities in terms of turnover, track record of profit, and various other parameters and criteria which one should have to comply apart from these rules in order to list their shares in the gift city exchanges. So apart from the Companies Act rules, the FDI rules, they would also need to comply the IFSI issue and listing of securities regulations 2021 in order to ascertain the other eligibility criteria that are required to be fulfilled for the purpose of listing in those stock exchanges. Next. So these are the companies which are not allowed to list. First of all, any company which is not listed here but has partly paid shares. So for any company who's eligible to list, it has to make sure that all these shares are fully paid. Then these companies like Section 8, Nidhi Company, company limited by guarantee with share capital, company having outstanding public deposits, company having negative net worth, company have defaulted in payment of banks, undergoing winding up, and defaulted in filing annual returns, or these are ineligible for the purpose of listing on these exchanges. In addition to, there are certain additional criteria as prescribed under the regulations of the IFSI for the purpose of determining your eligibility to list on those exchanges. Other important point is that any Indian resident cannot invest in an IPO of such companies when they launch their IPO on these stock exchanges in gift city. No Indian resident is allowed to invest, considering this as a foreign jurisdiction and as an FDI guidelines will be triggering. So only non-residents are allowed to invest in these IPOs of these company. Indian residents, they cannot invest in the IPOs of these companies. So anybody who intends to list can only raise funds through this listing route from non-residents, and person resident in India are not allowed to invest in these securities under the FEMA rules. Next. So this was the important point about the foreign listing. Then I think for last many years, government has been in a mood to do a lot of centralization of things, starting with CRC when it centralizes the incorporation related task of companies, and thereafter LLP with CRC. Then CPAs and other entities that they set up CPAs. Then there is also entity that looks after scrutiny of all the forms which are under STP mode. So there are already certain centralized agencies which the government has set up to look into various aspects of the forms that are filed under the Companies Act. Now, going forward, they have also taken another important step in centralizing the processing of certain key forms to begin with. So now these forms will not be processed with the territorial jurisdictional ROC, which were earlier used to be the norm. When you file a form, it generally used to go to your territorial ROC jurisdictional. and they processes those forms, marks for the submission or approves them, and the task is over. But now these forms, the list which has been which forms part of these rules, will now those forms will only be processed by a central processing center, which will have all territorial jurisdiction all over India for all the companies registered under the Companies Act, for the purpose of processing these forms. So once these forms will be processed, the jurisdictional ROC will not be processing these forms. And I think this is the list of forms which is significant and to begin with. And considering that many other forms are already in STP mode, these forms and another chunk of forms is now being sent to CPC, Central Processing Center. There will be a very handful of forms that will now be remaining with the Register of Companies to deal with. And I think the government's focus is to allow these offices to focus more on strengthening the adjudication system, inspection under 206 and other enforcement measure, while all the procedural aspect with respect to processing of forms, approval of the forms, will be dealt by these entities that are being set up for different purposes, starting with CRC and now with CPC. I don't see, as of now, I've not heard about any other such entities in works apart from this. But CPC, is an important step. While I believe that with the introduction of CRC, CPACE, there has been some increase in efficiency of timelines in processing these forms. But the challenge that I also personally face, that earlier in case of these forms, when they were dealt with ROCs, it was much easier for you to interact with ROC, the officials, to understand their problem, what was the issue, and then to resolve them. Then things get moving much easier. With the experience of CRC, which where you cannot have any personal dealing, it's a closed office. You can only interact through the help desk, through tickets. I don't know how easy will it be to coordinate with CPC if they can have some kind of very open kind of system where um, you can directly liaise through these officers, even through some VC facility or other facility, and or the ticketing system is improvised as opposed to what is there under CRC or other such agencies. I think then it would be a great initiative from the Ministry of Corporate Affairs. But otherwise, if we find challenges in understanding the requirements of the officers and then to fulfill, and the only interaction is by way of resubmission of the forms, then I believe it might take a longer time to get your forms approved than what was the case before the system of CPC, when we generally used to go to the jurisdiction ROC to meet them, make them understand our issues, try to understand what is their problem, and then try to submit the documents accordingly, and then the forms get generally processed and approved, since both of the parties are in connoissance with the requirements of either of both of them. So let's see how this will turn around in in times to come, and whether it's a boon or bane will the time will only tell. If we can move on to the next slide, I can just share a glimpse of the list of the forms that have been notified to be part of the processing under the CPC. Can we move to the next slide? So these are the forms, resolution of MGT 14, like many MGT form, MGT 14 under only those which are under not STP, and STP is also already going to a different agency. I think those where you need to kind of being checked, like for example, change in object clause, HS7, notice of alteration, INC 24, conversion related matters, return of deposits, all the forms under buyback, SH8, SH9, SH11, seeking of status of dormant to dormant company, then seeking of status to reverse status. So all these forms are now being shifted to the CPC with effect from 16th February 2024. Then another important change that I think we must have all heard about, change request form. Whenever we go to ROC for any correction in master data or many other corrections, this is the word that they always reach out to you with, is that we need to raise a CRF. that is the change request form. So this was earlier the form which was only in the domain of the registrar of the companies. You can go at their office, raise their request with them, and then they raise a CRF to the technical team, basis which they, when they approve the CRF, the relevant change automatically gets rectified, and you can see the change. Now, under the version 3, MCA has put this form open for the users at large. So instead of going to the ROC office and filing an application through them for raising an CRF, you can also submit a CRF. But there is a cautionary note along with the circular outlining the introduction of this form, that this form shall not be used unless and until the change is such which cannot be done with the help of any other form. So if there is a specific form through which the change is required to be done, then only that form is required to be filed. You cannot use a form CRF to you for that change. And in most of the cases, these forms will be used in my attention is with respect to changes in master data in predominant case, because this is the general cases where we have seen that in case of master data, in case of the charge data that appears under master data, only in those cases where there is a change is required and you submit an application and then there is a CRF. Then similarly, I think you can also use this form for filing those requests directly with the system. And once the request is processed, then the change will automatically defect. It is very clearly mentioned that filing of forms for requests which are cannot be approved through this form, for which there is a separate form is provided, which will be rejected without any reason. So this is a welcome move. I think at a lot of times it saves time in going to ROC office and submitting application. So many changes on MCA database in context of master data predominantly can now be done using this change request form, provided the requisite documents are submitted. Next. Then coming along with the SBO, under the Companies Act, you're already aware there is an SBO provision. Last year, similar provisions were issued under LLP, by way of amendment in LLP rules, and form LLP Ben 2, LLP 4D was introduced, whereby one form is for reporting by the beneficial owner, other form is for reporting to the registrar of LLPs for the purpose of the beneficial owner. While these changes were made last year, and the forms could not be made available till now, and therefore the government has extended the time for filing of the forms that were due to be filed at that point of time when the changes were introduced, and these now can be filed without additional fees until 15th May 2024, and the forms will be made available post 15th April 2024. So post 15th April, as of now, you will be able to fill and file this form, and the extended date is 15th May 2024. If you file till 15th May 2024, you will not be required to pay any additional fees. In case you file it after 15th May 2024, as of now, there will be an additional fees that you are required to pay. So we have to wait for the forms to be technically available on the system so that you can file. Securities law, there is a small amendment, there is a small change. I think the requirement of rumor verification that was there for top 100, top 50, which was earlier applicable from 1st October to top 100, 1st April to top 250, which then extended to 1st February, 1st August for 100 and 250. Considering that there is already a consultation paper that has been issued by SEBI to see comments on the further changes in this regime basis the requirement suggestions made by the Industry Standard Forum, on which we already had a webinar where we discussed the proposals made in the consultant paper. SEBI has now further extended the date to 1st June and 1st December effectively. And I hope till that time the final rules, the changes are also notified under the LODR regulations, so that companies will be in a much better position to understand the exact requirement of compliance, and ease of compliance will also be there considering the proposals that were made under the consultation paper. And from that date, the effective compliance will trigger. So this is all on the Companies Act and LODR amendment. I hand over this to now Amit ji to take this forward.
Thank you very much, Ankit. Uh, in my personal view, these developments which you have dealt with in company law, particularly the listing of equity shares in permissible jurisdictions and the CPC, that is they should welcome amendments, and they will usher in new uh, arenas of possibilities. I think they all welcome. I
Both
hope.
the things in both the issues, I think time will tell as to, like, for example, with respect to listing in permissible jurisdiction, let's see how companies, the benefits that they will foresee in listing, and what type of companies will opt for such listing. And considering CPC also, as I mentioned, if it is made in a fashion which is very user friendly and something different from CRC, I believe it will be, we would be in a much better position. But still, going to ROC, interacting with them, and getting the resolution of the queries, which was, I think, much easier, and it was within our, I think, comfort zone. Let's see how both the things turn up in times to come.
I'm sure. It will be a positive development because there was a constant problem faced by professionals that different ROCs follow different practices and they have their own uh, processes. So at least there will be uniformity with this new system. And as far as this permissible jurisdictions, the foreign jurisdictions, it opens, in my view, in due course of time, uh, possibility of Indian unlisted companies going for SPACs, because gift city regulations, they allow SPACs.
Yes, they allowed spec.
So
Sir, even
let us
Gift
see
City,
what developments take place, how they.
sir, even if you see, Gift City regulations also allow, for example, startups to
Yes,
list even without launching an IPO.
correct, correct.
So there are various provisions. I think we have to see in the course of time how these will be used by the Indian companies and including startups.
I think it opens a whole lot of opportunities for professionals to dive deep into these provisions and then advise the companies accordingly how they can do their funding. Thank you very much, Ankit.
I think Amit ji has still not joined. There
Uh,
seems
Amit
some
ji,
trouble. Team, if you can reach out to him. Sir, he is not there. He seems to be disconnected.
uh, he'll be joining. In fact, he's also traveling.
Amit sir is joining in our TomeNet.
So Ankit, you have 2 more minutes.
Yes, definitely. We don't have any question. Otherwise, I would have taken the question too. Sir, you can mute yourself.
2 or 3 minutes. He is in fact checking in at the airport, and once his check-in is over, he'll join us. Please bear with us and wait for 1 or 2 minutes. Yes. Over to you, Amit ji.
Sir, good afternoon. Apologies for bit delay. I was just on the way. So just give me a second. I'll just settle down.
Sure, please.
So if I'm audible?
Yes, please.
All right, sir. Thank you. So Shivam, you can change the slides. I'll take it. So very good afternoon to all, and thank you, sir, for giving this opportunity for sharing the important developments in the insolvency and bankruptcy code. And indeed, all these developments are a milestone development, I'll say, after a lot of hard work by many professionals and representations by the institutes. The IBBI has considered these requests and has agreed to the long pending demands from the uh, society, including the insolvency professional, including insolvency professional entities, liquidator, and corporators. The addressed all the
Amit ji, I think there is some audio
system,
problem.
but
You can switch off video.
if I'm audible now, sir?
Yes,
Is that better?
yes, please. Yes.
Okay, all right. So I was just trying to mention that these are the indeed a welcome change what IBBI has introduced very recently by mid of
I think there is again some audio problem. Amit ji.
insolvency professional entities of continuous apprising of these. Sorry. So I was just saying that journey will continue in respect of the professionals apprising to the regulator, and regulator coming out again addressing the issues what we have been facing in complying with the insolvency and bankruptcy laws. So in this regard, the first change which I wanted to discuss is in model bylaws, the governing board of insolvency professional agencies and the insolvency professional regulations. The change is that earlier we used to see that there was no provision in respect of resignation by the insolvency professional. Once the insolvency professional was given an assignment, either as a IRP or as a RP or as a liquidator or as a individual insolvency professional or as a bankruptcy trustee, he was not at all allowed and permitted to resign at any point of time. And it was a long pressing demand from the insolvency professional also that there should be some exit window available to the professionals in the genuine cases so that they can resign from the position if the situation demands. Now, IBBI has considered those requests and is giving you a window for resignation before completing the assignment. Even the only catch point is that the respective committees, maybe it is a committee of creditor in the CIRP process, if it is a liquidation, then stakeholder consultation committee, they will be requiring their approval for the purpose of your resignation. Their recommendation will be required, and also there will be a requirement to seek the approval of the adjudicating authority. So after you resign, the matter will be placed before the committee of creditor, and after recommendation of committee of creditor, the matter will be filed before the adjudicating authority. And once the adjudicating authority approves the resignation, you will be ceasing from the position of a respective position which you have been taking as a IRP, RP or liquidator. Until you are given the discharge from the duties by the adjudicating authority, you will continue to discharge your functions and responsibilities as a IRP, RP or as a liquidator. Shivam, you can move to next. Then there is another provision where there is one more explanation which has been added. We are aware that insolvency professional entity concept has been there for quite long time. And insolvency professional entity was a concept wherein many insolvency professionals were supposed to come together to bring their expertise on the table so that the best kind of services be provided to the corporate debtor in respect of their resolution, in respect of their liquidation, in respect of their other matters. Now, challenges which insolvency professional entities acting as a IP, there were many challenges, and time and again with representation, IBBI has relaxed the restrictions on IP entity. Similarly, now 2 more relaxations have been given by the insolvency professional for the insolvency professional entity by the IBBI. And one is that IPE can engage its partner or director for the purpose of undertaking any assignment in respect of any CIRP or liquidation matter. Now, only restriction which continues is in respect of valuation and audit. Because as we know, these valuation and audit are an independent function. And if these functions are also allowed to be continued by the IPE, then the entire independence issue will crop up. So these things have not been allowed. But other than that, the other services can certainly be continued and provided by the IP itself. Now, second departure from the previous position that has been done by way of an explanation, where IP is acting as a IP for providing services other than valuation and audit in connection with an assignment which is undertaken by its partner or its director. So earlier there were restrictions with regard to these provisions. Now, with the introduction of the relaxation, these IP entity will also be eligible to provide these services. One more change that has been done, that is in respect of authorization for assignment. You may recall couple of years back, the regulator has introduced the seamless concept of empanelment, whereby the adjudicating authorities used to empanel the people, the insolvency professionals, for the purpose of giving their names for appointment by the respective adjudicating authority. Now, challenge was that how the adjudicating authority will know that whether the person is eligible or not, whether any disciplinary proceedings are undergoing against him or not. And many a times it was seen that at the time when the name was proposed, name was approved by the adjudicating authority, and later on it was found that the disciplinary matter is going on and the entire process was repeated. So the time waste was there. So the concept of authorization for assignment was introduced, whereby the regulator was verifying the details and empaneling the people by giving the authorization that you can continue to work for another 1 year. It was kind of a license and certification that no disciplinary proceedings are initiated at the time of issuance of that AFA. So you are empaneled for a period of 1 year for which the AFA was issued. Now, in this regard, also one unification is being proposed to align the AFA with the empanelment period. Right? Empanelment currently is for the period of 6 months. So they are saying ki, for every instead of having the validity of AFA for 1 year, it will be aligned with the appointment by the panel which is prepared by the adjudicating authority. So it will coincide with either June, December, irrespective of your application and your approval for AFA. That is another change that IBBI has made in regard to AFA. Shivam, we can move to next. Then there is a change with regard to the personal guarantor to the corporate debtor. As we are aware, these provisions were notified immediately 3 years after the notification of the Insolvency and Bankruptcy Code on 1st of December 2016. The law was effected, and 3 years after, that is on 1st of December 2019, the PG to CD cases were brought into force. Now, we have seen that in the last 3.5 years, almost majority of the issues with regard to the constitutional validity, with regard to challenges to many of the provisions of the individual insolvency, the landmark judgments have been issued by Supreme Court and these issues have been settled. Now, cases are moving forward towards yielding to some positive results. So in that direction, the IBBI has also moved one step forward, and they are now coming out with certain tweakings in respect of these particular provision. And one such change was earlier, there was a restriction that the person who has acted as a interim resolution professional or a resolution professional or as a liquidator was not allowed to take up the assignment as a individual insolvency professional at the time when the individual insolvency was initiated. That is, personal guarantee to the corporate debtor cases were initiated, then he was disqualified. If I was a insolvency professional at the time when the respective CD went into CIRP and I was acting there as a IRP, RP or as a liquidator, then I cannot be appointed as a insolvency professional when the guarantor, that is the director or a promoter who has given a guarantee and the insolvency proceedings are initiated against him. Now, a lot of arguments had undergone and a lot of benefits have been explained to the regulator. And ultimately, IBBI has got convinced that we see that there is no challenge in considering his appointment here in the PG to CD cases also, because in any case, he is a person who is regulated by the professional body, IBBI, and he cannot be supposed to be biased in respect of any of the processes. So now on, even the person who is the IRP, RP or liquidator in the CD can be appointed as a insolvency professional. And the logic that has came out in the discussion paper also, that he'll be in fact in a better situation, that he may be having many more information which the other insolvency professional may not have, because he has already run the process of 330 days in respect of a CIRP process. So he may have digged out more and more information than anyone else. The time, in fact, will be taken by him, which will be lesser in comparison to a new IRP or RP. Yeah, Shivam, we can move to next. Then there is a another change that is in respect of the repayment plan. There was, when this law was introduced, there was no concept of meeting of committee of creditor. In fact, there was no concept of committee of creditor at all in the PG to CD, that is individual insolvency. In the case of corporate insolvency, there was always a concept of committee of creditor, whereas in the individual insolvency, there was never a concept of a committee of creditor. There was, though the regulation enabled that if the RP feels necessary, then he may call a meeting of committee of creditor, but that was not a mandatory thing. But now, in the last 3.5 years, the regulator has observed, on the basis of feedback what the insolvency professionals have given, that there are a lot of complexities involved. Even I will go to the extent of saying that the complexities in the individual insolvency are far more than the complexities involved in the corporate resolution, because of the fact that corporate is a registered entity in respect of whom there are a lot of agencies with whom the data availability can be ensured. Whereas in respect of individual, it is very difficult to find out an agency who will be recording all these informations in respect of an individual. So it is a highly challenging task for an insolvency professional to run the CIRP process the repayment plan. So in those cases, lot of conflicting claims are coming, lot of conflicts are there. So it was considered necessary that better to make it mandatory that in such cases also there will be a meeting of creditor, so that the financial issues, the interdependencies issues, involvement issues, and the efficacy can be brought in and the issues can be sorted then and there itself. With that objective, this particular change has been introduced. Shivam, we can move to next. Now, another change is in respect of the voluntary liquidation. We know that Section 59 of the Insolvency and Bankruptcy Code has proved to be quite useful to the corporates who were having lot of surplus funds in their books of accounts, and they were not able to find out a way to liquidate that fund. Because if you try to declare it as a dividend, then you are stuck, because you cannot take out the 100% of the money. Then if you want to take a buyback route or any other route, that was not getting affected. That was not very effective because of the various challenges involved. And time taken was also much. So voluntary liquidation proved a quite easy methodology for the purpose of taking out those money and putting the company also to the dissolution and making a death of a company. Now, in that process, the conditions were like the company should be solvent and the other requirements are there. Now, one of the challenge that insolvency professionals has brought to the notice of regulator, that at the time when the resolution is passed by the shareholders of the corporate debtor for commencement of voluntary liquidation, we are not aware as to what is the status of their legal proceedings. What is the status of likely possibility to complete the litigation? So many a times we have seen that the timeline which has been prescribed by the regulation with respect of completing the dissolution process is surpassed, and we are not able to complete that. And primarily reason is the pending litigation. The same reason is in respect of liquidation matters also. And for the same reason, even the voluntary liquidation matters are also held up and they are not closed. So regulator has now given a mandate that the corporate person, when they will be initiating the voluntary liquidation process, they will make the disclosure with regard to the pending proceedings or assessments which are pending before the statutory authority. Like your income tax refunds are pending before the department, maybe GST credit is pending, or likewise, or maybe the issues are pending with the provident fund authorities. So all these pendencies are required to be brought to the notice of the insolvency professional who is going to take the responsibility as a liquidator. And then basis that the call will be taken, at least the knowledge will be available to the information will be available to the liquidator as to what is the status and how much time it is likely to take to complete the process, whether the voluntary liquidation process should be initiated at this point of time, or should we complete the litigation and then we commence the voluntary liquidation process. That is the precise reason due to which this voluntary liquidation process regulations have been also amended. Shivam, move to the next. Now, another change in respect of voluntary liquidation process that has been made, that if you are not able to complete the liquidation process within the given time frame, then you are required to hold the meeting of contributories and present a status report within 15 days from the end of that particular timeline. And after that, every succeeding period, also you are required to continue the same process. That means you will be continuing the contributories meeting and presenting the status report. And this process will continue until the whole process of voluntary liquidation is completed. And not only this, the law has mandated that if period after submission of the final report, but before the corporate person is dissolved, stakeholder claiming entitlement to funds in the corporate voluntary liquidation account, they can apply to the liquidator. So you are aware that if as a liquidator, I am not able to distribute certain amount, right? Maybe I have found out a person, but he is not providing me his bank details, or he is not traceable, or due to any reason the credit could not be completed despite my best effort. Then the law has provided that I can transfer the amount to the corporate voluntary liquidation account, and the amount can be claimed in the same manner as now it has been provided in the regulation 7A, 7B, 7C, 7D of the liquidation regulation. We'll discuss that when the liquidation amendments will be discussed. But now from the voluntary liquidation process also, the amount can be deposited, A, and the claimant can also make a claim after even submission of the final report, but before the dissolution process is completed. Shivam, next. Now, in liquidation process, there are quite a lot changes in liquidation process regulation and also in the CIRP regulation process. The first change which I may like to discuss is the flexibility provided to the liquidator. See, one thing which I can outline as a major change that stakeholder consultation committee in the entire liquidation process has been given lot of importance, and lot of responsibility has been given to the stakeholder consultation committee. As we progress, we will see that a lot of new provisions have been added in his role, responsibility, duties, and that is rightly so, because it is observed that unless the stakeholders who are involved, who are into the process, they also take the ownership in respect of completing the liquidation in a timely manner, the maximization objective of a liquidation process may not be achieved. So similarly here also, if liquidator decides to reduce the reserve price by 25% in respect of any of the assets which has been put to auction, he can do that, but that process can be done only once, and that's too with the approval of stakeholder consultation committee. Because time and again the requests are made that if I am not allowed to make the reduction in the reserve price, maybe beyond up to 25%, up to 25% range, then in many situations it is getting delayed. It is delaying the whole process of completing the liquidation in a timely manner. So there are situations where I can protect the interest of all, and despite making my best effort, I am not able to do, and I have a reasons to justify as to why a liquidator wants this particular reduction. Then with a check of stakeholder consultation committee, the power has been given that yes, you can go ahead with the stakeholder consultation committee, take their advice, and if they advise, then accordingly you can consider for one-time reduction in the reserve price. Secondly, where the fresh valuation is conducted, in those cases also the reserve price can be reduced up to 10% in subsequent auctions. That has also been provided in terms of the regulation. Yeah, next. There is one more provision with regard to the sale of assets by the private sale. Now, earlier there were many provisions, as many as I believe 3 provisions were there with regard to disposal of assets by way of a sale. Now, earlier there was an option that if asset was sold at a price higher than the reserve price of a failed auction, then private sale was allowed. There were 3 situations precisely, if I can recall correctly. Then the first situation in which the private sale that was allowed was one where you were able to fetch out the price higher than the price what was a reserve price of a failed auction, which was in regulation 33 sub-regulation 2. Now that clause has been deleted. Now, even if you are able to fetch out a higher price than the failed auction reserve price, then even you cannot make a private sale. Now, only 2 options are available for a private sale. That is in respect of assets which are perishable in nature. Secondly, if the assets are likely to deteriorate in value significantly if they are not sold. That means again a livestock only. If you have a standing crop, or if you have fish, or if you have something which is perishable in nature, and the value of which is likely to deteriorate if they are not sold, in those situations only you are allowed to do so. And also, earlier there was no consultation of stakeholder consultation committee. Now you are required to take the consultation of a stakeholder consultation committee also, even for doing any kind of private sale. Only two kind of private sales are allowed, and for that also you are required to take the permission of stakeholder consultation committee. Another major change, I will say, that is the change in the CIRP regulation also, in respect of putting a discipline to the all committees, whether it is a committee of creditor, whether it is a stakeholder consultation committee. Now, change is that you have to mandatorily hold the meeting of committee of creditor or the meeting of stakeholder consultation committee at a gap of 30 days. That means there will be one meeting in each month. However, one relaxation has been given, that the stakeholder consultation committee or the committee of creditor in the case of CIRP, if they feel that in their process of CIRP or liquidation, they are not having a requirement of meeting every month or at a gap of 30 days, then they may pass a resolution to that effect, that we will meet only at a gap of 60 days, 90 days, or whatever is decided by them. But you have to take a positive action. Law is like that only, that you have to compulsorily meet at every 30 days so that the process can be expedited. See, the spirit is that you should not take it for granted. You should not keep on holding the delays in the meeting, and you are not allowing the stakeholder to come and meet and get the issues resolved. So that is why the compulsory provision has been brought in. It has been observed that in many cases, many of the members of committee of creators were trying to sort of delay the whole process by not allowing the easy happening of the meetings. Now, the law has mandated, and if at all somebody is taking a call that no, in our case, we want this time gap of 30 days to be extended to 60 days, that can be done. But those will be the exception cases. Shivam, next. Now, there is one more mandate, again in the direction, I think a step in a right direction to expedite the process of liquidation, that although many of the liquidators had been doing this already, it is not that we were not doing, but a comprehensive report has been mandated to be presented in the meeting of stakeholder consultation committee. And this comprehensive report will include a report of progress which is made in the liquidation process, consolidated status of the legal proceeding. And we were just discussing some time back that legal proceedings continuance during the liquidation process is a bottleneck for resolution of entities which are under the liquidation. So to give an emphasis, I don't know how much it will work, but at least there will be a onus on the stakeholders who are part of the consultation committee to find out ways and means to take a corrective step as to why these processes are still continuing, and is there a way or means by which these processes can be expedited. And additionally, if a liquidator want to continue any legal proceeding or any legal matter is to be pursued even after continuation of the liquidation process, then he has to give a rationale as to why he want to pursue the proceeding. Because in many of the disciplinary matter or the review of the liquidation processes, it has been observed that the liquidators have been holding the litigation process or have been pursuing the litigation where the cost of liquidation is increasing, and the value, the economic value which can be fetched out by winning that particular litigation is far less. So the rationale, maybe I am seeing a light of the day that perhaps tomorrow if a liquidator has to take a call, then he has to act commercially, that if a value which is going to come out after winning a case which is continuing in a liquidation matter is likely to be less than the efforts which are going to be made out of this, or the time that is going to be spent, then he may withdraw that particular matter, and the proceedings may close, and it can lead to the dissolution process also. So I think I step in a very right direction, where the checks has been made by way of asking the liquidator to put a comprehensive report, progress report, check on the liquidation litigation, and providing a mandatory requirement of a rationale also. Another change is with regard to the valuation. There are two major changes. One, and these changes are common in respect of CIRP regulation as well as liquidation regulation. One change is that now you have to invite the registered valuer to explain the methodology adopted by them for the purpose of doing the valuation. Because many a times there were non-clarities as to what methodology the registered valuer has adopted in respect of making a valuation. So there may be many questions of stakeholders. There may be questions of the committee of creditors. So they may understand, and if there is any input from their side, that can be provided to the registered valuer then and there itself. That is the first change, and they have to arrange this kind of meeting. Then second is the change in respect of the sharing of a valuation report with the stakeholder consultation committee members. Of course, they will be required to provide the confidentiality undertaking, and once they provide the confidentiality undertaking, these valuation reports can also be shared with them. Next, Shivam. Now, if a liquidator decide that a particular corporate debtor can continue as a going concern, up till now there was no provision, and at his own decision he was deciding whether to continue or to stop. Now, if he has to continue the corporate debtor as a going concern, then the consultation of stakeholder consultation committee is a must. Because ultimately, who are the beneficiaries are represented in the committee by way of these stakeholders, and they have to decide. Maybe you are running a company as a going concern, but it may be burning your cash.
Amit ji, your audio is not working.
Okay.
Yes.
Now it is better?
Yes, Amit.
All right. So I was just sharing that in case of going concern, now if a liquidator decides that he want to continue the entity as a going concern, then he has to go back to the stakeholder, ask them that this is a feasibility report.
Video चालू कर देगा ना मेरा वाला भी.
So after that consultation, if the stakeholder consultation committee permits that yes, you can continue a corporate debtor as a going concern, then you will be allowed to take the company as a going concern. Another change in respect of this particular provision, in respect of sale of corporate debtor as a going concern, another change is that if you are completed with one attempt of sale of entity as a going concern, then in the subsequent options, only one option you have been given to put forward for sale of CD as a going concern. After that, you have to give multiple options. The other options which are provided, if this option fails, then you have to share the marketing strategy in consultation with the stakeholder consultation committee, and accordingly we have to provide the other options for the sale of assets also, instead of just giving one option of sale of entity as a going concern only, which was earlier available, but now it is no longer going to be available. Then if you are intending to make an application for early dissolution, then you can do so. Earlier also that was provided. Now only thing is that a detailed report will be required to be placed before the adjudicating authority after the views of a stakeholder consultation committee. So again, here also the stakeholder consultation committee becomes important part, and their recommendation has to go along with the detailed report. Then if we see to provide the essence of information in respect of realization and distribution, the compliance certificate under Form H has been modified. Form H was earlier also there, but there are certain new blocks which have been added to capture the information as to what realization you have made and what distribution you have made in the complete process. Yeah, Shivam, next. Now, next process, again continuing in the liquidation process regulation only. I think couple of more changes are there therein. That after submission of the final report, that was I was talking about, that if your entity was having some points which were not possible to be distributed during the liquidation process, so you will open the corporate voluntary liquidation account, and there is a new form I which has been introduced for the purpose of claiming, and the distinction has been made as to how you will claim the money if your dissolution process has not been completed, if your final report has not been submitted, or even after the dissolution is passed, the money can be claimed. Yeah, now question comes, if that is so, then that means how the liquidator will continue to facilitate the verification of these claims, because he has been drafted a claim. So until the dissolution process is over, I can understand. But once the dissolution process is over, after that, even the responsibility will continue in respect of amount which is lying in the corporate voluntary liquidation account. This is something that needs to be, I think, if not revisited, but at least streamlined, so that tomorrow the challenges should not happen in respect of these things. And additionally, what I can just see that the amount of fees should be adequately captured, that tomorrow the kind of obligation of a liquidator will continue even after the dissolution order. So if I am, let us say, parking the money of 5 crore, which is in the corporate voluntary liquidation account, and the claimants are 1,000, then adequately protect your inclusion after even the process. It is not that IBBI who will be distributing that money. IBBI will be doing only on the recommendation made by the liquidator. I don't know how far. I'm sure the IBBI must have examined this particular aspect from the practical applicability perspective also. But these are the issues which are required to be evaluated by the stakeholder as well as the insolvency professional with regard to the practical feasibility perspective also. Then one more change that they have introduced is in respect of Now, only change which I can see in respect of 2B regulation is this amendment, to my mind, is just in the nature of clarification. Earlier also, the provision was same, and under regulation 39BA of the CIRP regulation, the recommendation of committee of creditor was required to be made in respect of compromise or arrangement under regulation 2B. Now, only change which I can see is that committee has to make the recommendation, and the proviso which has been added is saying that the liquidator shall file the proposal of compromise or arrangement only in those cases where such recommendation has been made by the committee under regulation 39BA. Now, earlier also he was making a recommendation, but recommendation was more in a form of exploration of compromise or arrangement. Now, I'm asking this question to myself as to what change the committee of creditor will make in their recommendation. I feel the role of a committee of creditor will not be just limited to making a general recommendation that you explore the possibility that, but it will be more kind of a more authentic recommendation wherein you are giving a mandate that a proposal for compromise or arrangement should be considered and examined, or should be explored, or there is a strong possibility kind of thing. Otherwise, so far, there is no change in regulation 39BA, but I hope that that kind of clarification may be issued. Otherwise, they may be thinking that by changes which are made in the 39, this regulation 2B, that particular part can also be covered. All right. Then the last change in the liquidation regulation is the liquidator may extend the payment period of the balance sale consideration beyond 90 days after consultation with FCC. This is a genuine request from the liquidators, and now they have been permitted by the IBBI, and only request is that they should take the consultation of a stakeholder consultation committee before they move ahead in this direction. Shivam, next. Shivam, you can move to next slide. Yeah. Now there is one more significant change, and quite significant change. Shivam, go to previous one. Last change on the liquidation regulation, and that change is that if any real estate allottee has been given possession in respect of any of the flat or any of the real estate project, the word used is possession. If the possession has already been given, then that particular real estate cannot become part of your liquidation estate. That will be out from the liquidation estate if it has been already given the possession. That is the change that has been introduced. That is the, because a lot of litigation was there in the adjudicating authority by the real estate applicant who have applied and who have got even the possession also. There were different kind of litigations, but one very common litigation was that since we have been given the possession also, then why still there is a long lot of people who have been who have paid the entire money and who have not yet been given the possession, but whose flat is ready. So they are also before the IBBI claiming that why we have been left out, why our claim has not been considered, whereas since my flat, the allocated flat is ready, then in that case we should also be provided a parity. But I think that is the issue which is to be considered by IBBI. In times to come, they will consider this particular point also. Then there is a small change in the Form A for capturing more information in respect of details of meeting, gap between the two meetings, dissenting notes and all. Yeah. Shivam, we can move to the next. Now, in CIRP process, if I can start with the real estate itself, the major change is that you are mandated to open a separate bank account in respect of each the real estate project. So, if there are corporate debtors who are having, let's say, 5 projects, then in respect of all these 5 projects, you will be required to maintain a separate bank account. In any case, I believe RERA has already had this similar kind of provision, wherein for each project you are required to maintain a separate account, but that provision has now been through the insolvency and bankruptcy code also. The other changes with regard to the meetings of Committee of Creditor, as we have discussed already in respect of the meeting of Stakeholder Consultation Committee. Similar change is there in the Committee of Creditors meeting also. The time gap is not more than 30 days, but Committee of Creditor can extend this 30 days period to the further extended period as they wish. But at least one meeting in each quarter is required to be held as per the particular provision. The gap between the period can be more, but at least one meeting should be there in the each quarter. Yeah, Shivam, next. Now, there is a significant change in the voting procedure. And the change is like earlier, the resolution professional was holding the Committee of Creditor meeting. Once the meeting was over, within 48 hours, he was supposed to circulate the minutes. And after that, at least for 24 hours, the voting windows were required to be open. Committee of Creditor and me and we were getting the request from the Committee of Creditor that this voting line be extended for another 1 week, then again 1 week. And in many cases, we have seen the timeline for maybe in certain, but we have seen the cases where the voting lines have remained open for 45, 60 days also. So to put a check on the Committee of Creditors also, the law has been amended to provide that the Committee of Creditor can decide to provide e-voting for maximum 7 days. That is the maximum time that has been provided. Minimum 24-hour continues. Earlier also it was minimum 24 hours. However, Committee of Creditor can decide that the voting lines will remain open for 7 days, which will be in fitness of the things. Now, instead of giving the open window that you can or not providing for anything as to how many times the extension can be given, the check has been put by way of saying that the Committee of Creditor, the resolution professional, can provide the extension of timeline by 24 hours on each request. So if I am a creditor, I am a member of COC, I could not vote, then I will request to RP and RP will extend the timeline by 24 hours. But at each time, the request will be only for 24 hours or RP will extend only for 24 hours. It cannot extend beyond that. So in one go, after 7 days, 7 days is a time which is permissible by the COC itself. So after 7 days, you can get extension in the block of 24 hours only. So before, let us say, (2024), and the timeline of today is completing before midnight of 12, we get a request from committee of creator for extension. So voting line will continue till tomorrow, that is up till midnight of 2nd of, and then it will be extended to 4th. Otherwise, the voting will be completed. Now, the question can be asked as to how many times this 24-hour extension can be. The answer is there is no limit. It can be virtually unlimited. But at least there is a check on the member of committee of creator that how many times he will continue to make a request that kindly grant extension of 24 hours. And in bona fide cases, the matter can be placed before the adjudicating authority also if we want to close the matter. And I'm sure this is going to bring a very positive change in the behavior of a committee of creator also in early disposal of the matter. There is one more provision which is also very interesting to note, and that provision says that this 24-hour additional time that the resolution has already received the requisite majority vote. Now, this is very tricky. At least I am not able to understand that what the regulator wants. Is the regulator saying that I have a flexibility to open the voting result and see whether the resolution is passed or not? Because in e-voting process, we know the result only after the voting is closed. And once I have closed the voting, then where is the question of again opening it? And if I have not closed, then how I will come to know whether the resolution has been passed with the requisite majority or not? I am not very sure about what the regulator intended, but I am seeking a clarification from the regulator in this particular regard as to what is the intent by using this sentence of maximum period of 24 hours. I am still not aware, but yes, we have sought a clarification from the regulator. Now, there is one more check on the insolvency resolution process cost. Already there was a provision that all the cost of CIRP shall be considered and approved by the committee of creators. There is no dilemma, no debate. Only check point is that now these costs are required to be part of each COC meeting and they will be approved. So you will be having a running account kind of thing where you will be putting the cost heads of CIRP cost, and in that cost head you will be adding up the value of the respective particular quarter or respective period, and then providing the cumulative value also for information and for the approval of the committee of creator. Next. Shivam, we can move to next. Committee, the provision with the registered valuer to discuss. There is another provision which is again very interesting. At least I like that provision, very interesting. That is with regard to disclosure of the fair value in the information memorandum. And of practice in the market, some professionals were disclosing this value and some professionals were not disclosing this value. Now, the debate that will start now, because the power has been given to committee of creditor to decide whether they want to give the information in the information memorandum or not. If they decide that they don't want to give the information in the information memorandum, then they have to record the reason in writing. And they have to decide why it is not going to be beneficial to disclose the fair value in the information memorandum. And if they record, then they are not required. Otherwise, the fair value has to be mentioned therein. So this is going to be a very, very significant change. It can go either way. I'm sure the flexibility has been retained and the ultimate decision has been left at the wisdom of the committee of creditor to decide that in selective cases where they feel that I can unlock more value and giving a benchmark price of fair value may stop the resolution applicant from bidding on the higher price. This debate, I'm sure we will recall the 2016 and 2017 when the initial phases were going on. Then also these kind of debates were there because the clarity was not there. Over a period of time, the law has got settled. And now the regulator has also given a kind of clarity that yes, by default, you have to give unless COC decides otherwise. Now, in real estate cases, we have witnessed the reverse insolvency. Going forward, the Insolvency and Bankruptcy Board envisages that the real estate cases may be resolved or project-wise also. And they have enabled the invitation of resolution plan for each project separately. Now, not many details are there. So far, only enabling provision is there. And me and you will agree, even the reverse insolvency was not there. A kind of from Supreme Court and also by NCLAT order. Supreme Court has not admitted the appeal. So in a way, kind of accepted by the Supreme Court also. But NCLAT has very categorically upheld that reverse insolvency is a possibility. And now Insolvency and Bankruptcy Board also has kind of legalized the reverse insolvency by allowing the project-wise insolvency resolution plan invitation. So it would be interesting. I think only time will tell how far this provision and this flexibility is going to be beneficial. But yes, enabling provision has been there in the now in the statute book. We can move to next figure. Now, there is one more change which is major one. There was no concept of monitoring committee in the Insolvency and Bankruptcy Code. These provisions were introduced by way of a mention and inclusion in the resolution plan. When we were preparing a resolution plan, we were mentioning that there will be a monitoring committee, there will be this responsibility, this duty. Now, the regulation has been amended to provide that the monitoring committee may be there. And even it has gone to the extent of saying that committee of creditor has the power to constitute the monitoring committee in their own manner, in their own discretion, even if the resolution plan provides or it does not provide. So that is the kind of flexibility and kind of power that they have provided. And one more check has been provided where the insolvency professional who has been RP in the matter, he has been made a part of monitoring committee, then his fees cannot exceed the fees that he was getting during the CIRP process. But this restriction applies only to the person who is working as a resolution professional earlier. If I am appointing someone else other than RP as a monitoring committee member, then there is no restriction with regard to the payment of fees to him. Of course, it will be reasonable, but point is that there is no restriction to him. There is one more small clarification that if your extension application is pending, although we have been doing that, if my extension application is pending, you have to continue to discharge the duties as a RP. You cannot just get yourself discharged by saying that since my application is pending, no longer does not become a functus officio. Essence is that you continue to be a functional in charge until the final order comes. Shivam, next. I think major part we have covered. There are just few circulars which we can just have a glance, although major part of these circulars have also been covered in the regulation itself. But just to sum up, the first circular is in respect of the RP under IBC examines the application and submit a report to the adjudicating authority. And it has been observed that he is not sending any of these reports to the debtor and creditor, which is like there is an information asymmetry. The stakeholders are really not aware as to what is the status of their matter. So now the transparency and quicker decision making demands that these reports are also to be shared, of course, with the non-disclosure undertaking. Next, Shiva. Then there is a small clarification in respect of voluntary liquidation. We know that insolvency and bankruptcy code applies to corporate person who are not covered under the financial service provider. If you are a financial service provider, like you are a stockbroker regulated by the SEBI, then you are out of the ambit of insolvency and bankruptcy code. And IBBI has came to know about certain cases where the entities which have been part and parcel of the financial service provider, they have also been voluntarily liquidated. Just as a matter of check, they have provided that it will not happen unless and until there is a adequate permission from the respective regulator. So you have to just ensure that necessary permission from SEBI, RBI is there in place before you undertake such kind of assignment. My only point is that I am sort of confused with this clarification as to whether government is trying to say that the entities which are completely excluded from the purview of insolvency and bankruptcy code, that is financial service provider, they can also be voluntarily liquidated after taking necessary permission from the respective regulator. I don't know how it is going to be possible, because when the law itself says that you're not going to be covered in the insolvency and bankruptcy code, then how come this leeway will be possible? But I think IBBI will clarify in some of their clarification and circulars. Then there is the further information that liquidator is required to submit the documents to IBBI via a designated email ID they have provided. Still, we know the reporting mechanism is not as robust as in the case of a CIRP. So until the robust mechanism in respect of disclosure of voluntary liquidation process comes into place, till the time we have to continue with the sharing the information by sending the information on the email to the designated email ID. Shivam, we can move to next. Then there is one more change which we have already discussed, that is in respect of deposit and withdrawal of unclaimed dividend. Regulation 39 mandates liquidator to deposit unclaimed funds to the corporate voluntary liquidation account and inform to IBBI. And the stakeholders are allowed to claim their amount via Form G. And the detailed process has been prescribed as to in what manner they will be able to withdraw the amount from them, if they are withdrawing before the report submission, before the dissolution order, and after the dissolution order, as we have discussed, I think, earlier also. Yeah, Shivam, next. Now, this is again the repetition circular of circulation of the progress report to stakeholder. So, Regulation 15 of the liquidation process regulation mandate that the quarterly progress report is required to be submitted to the adjudicating authority and to IBBI. These reports, of course, has not been mandated to be shared as of now to the creditor, where the again the information asymmetry arises. So they are now mandating that these reports will be required to be shared to the stakeholder consultation committee also, after taking necessary non-disclosure confidentiality agreement. Yeah, Shiva, we can move to next. This regulation 13 has also been partly amended with regard to the preliminary report, which requires the liquidator to submit a preliminary report to adjudicating authority outlining the liquidation process. This regulation currently does not require any consultation of the stakeholder consultation committee. So they have now mandated that even the preliminary report will also be required to be reviewed by the stakeholder consultation committee, again giving a sense of onus and responsibility to the stakeholder consultation committee right from the inception of the liquidation process. That is the idea, basically. Yeah, Shivam, we can move to next. Again, Form H, we have discussed that a dedicated email ID has been provided, that Form H, which is now more descriptive, where a lot of details with regard to distribution, with regard to realization have been mandated. They will now be required to be shared in a designated email ID to the until the platform is designed and developed by the regulator. Next. Again, I think this we have already discussed, Regulation 46 in respect of unclaimed deposit. The same process we have to follow. Already we have captured. I think there is nothing. So I think we are done with the a long list of changes what IBBI has brought in after a long time and efforts of all the stakeholder and the insolvency professional. Thank you, sir. Thank you for giving this opportunity to share with you. And my apologies that I could not keep my video on because of the network issue. I am traveling currently, and maybe you have missed out some voice also. There may be some noise. I am currently at airport, so my apologies for the same. Sir, please go ahead.
Thank you very much, Amitji. It was a marathon presentation, and you have very lucidly covered the subject. The amendments were many. To sum up, in my personal view, the liquidation process through these amendments has been considerably rationalized.
Yes.
The resolution process for corporates have also been rationalized. So I think some delays can be cut and the process will be expedited. The liquidations will be faster. Is a question? Take the question for you. Amitji?
Yeah, please, sir. Yeah, please.
There is a question for you. As per amendment, in case of voluntary liquidation, meeting of stakeholders is to be held within 15 days of the end of 90 days or 270 days, as the case may be. In one case, liquidation commenced on 26th February 2021. So every year we had prepared annual status report. In view of amendment, the end of 90 days will commence from which date? Date of amendment or the date of commencement of liquidation?
Date of
Your
commencement
view,
of
please.
liquidation. Yeah, it will be certainly from the date of liquidation only. I understand the point from where the person is coming, because the amendment is now getting enforced with effect from I think 15th of
24th of January, isn't it? 31st of January.
Yeah, 31st of January. So the question is whether it will be effective from 31st of January, you will get a time, or so in my view, the people's whose timeline, let us say, is expiring on 1st of February itself, it will be injustice to say that your time period will be expiring. So the first cut of people will be getting the benefit of 90 days also, right? I
Right,
can
right.
reasonably say that yes, you can, as long as being in compliance with up to within the 90 days from the date of coming into force of this notification. I think that will be a fair view. But other than that, from next year onward, I think this issue will not be there.
I totally agree with you. That is a very fair view. Now, there are a few queries. What would be the logic behind transferring the powers of ROC to CPC? How will it be beneficial to corporate governance, etc., etc.?
So I think that is not the question. I think that was addressed to Ankit, but
Yes.
let me take that question. The point is that this government has been working on a major reform in the transparency and governance. And they have a strong belief that they can achieve that through bringing digitization and bringing centralization of all things at one place, right? So in that direction only, and if you see in their working also, in all the department, they are trying to consolidate the things at one place so that they can achieve the excellence in that particular process. So if one person is going to process one similar kind of application, they are thinking that the time consumed in processing the application will be less. Of course, I agree the point what Ankit was also trying to say, that the stakeholders are facing a sum of difficulty, that we are not getting a reach to the respective registrar in respect of raising our issues or problem. But I'm sure the government is pretty aware about these issues also, and in times to come, they will provide a adequate resolution mechanism for the same also. In times to come, I'm sure this is going to be a order of the day, and this will only work. The way they are trying to, the human interface, you see the income tax, faceless assessment, the changes which are now introduced even in the adjudication process. Now, they are also going to be digitized the same way that we have been debating, and now they are going to be seeing the light of the day. Same way they are now having a CPACE and shifting the form approval also to CRC, where no human interface is possible. Tomorrow, these forms may also be masked, that even the person will not be able to see which user has filed these forms. I think that will not be very difficult in the technology. Already, I am told that the incorporation process has already been masked. That the person who is sitting in the CRC office is not knowing, is having a no possibility to know as to who has filed that particular application. I think the idea is that you break a chain of intervention as to know who is the person who is beneficiary and who is the person who is the approving officer. I think the corruption possibility will reduce over a period of time. That is the idea. How far it will benefit, but we are in a transition phase, so definitely we are going to suffer for some more time. That is my view.
No, I quite agree with you, Amitji, because the thinking all along has been, and if you read even the various committee reports also, is that the jurisdictional registrar should be freed from routine jobs so that they can concentrate on their investigation work, the inquiry work, there are many more things which go which are at the hindsight, which do not get the adequate attention of the ROCs.
Yes.
So I think it's a very
absolutely.
welcome, very welcome move, and this will also result in uniformity in systems. And Today, we all know that from ROC to ROC, processes differ, systems different, there is no uniformity. So I think the direction the government is moving in a very right direction, and in due course of time will settle. Finally,
absolutely.
we running short of time. There is last question I'm taking, Amitji, for you.
Yes, sir.
Whether the amounts due to landowners of joint development agreement projects will be settled on priority.
No, I don't know why this question is there, because perhaps when I was mentioning that the people who have been given the position in respect of real estate, those will not be forming part of the liquidation estate. From there, I think he's drawing this conclusion. But I'm not sure as to what is the arrangement in respect of this joint development agreement, as to what kind of disputes are in between the parties with regard to this particular matter. I'm just presuming that there is a corporate debtor, there is a joint developer who is party to the same. There is one person who is having a land, and the other party is developing that particular land, and both parties will share in a agreed proportion for the purpose of benefit out of the commercial project. Now, if the entity goes into the CIRP process, the question comes with regard to the settlement of dues of the one party or the other. So either the party who is having a land may have a claim against the other party which has gone into the CIRP, or the otherwise. So it has to be seen as to in which shoes the person is, but that particular clarification what the IBBI has brought in, it has nothing to do with a joint venture, joint development agreements as such, right? So the position remains the same what was earlier. I see no change with particular regard to this. I think one question is with regard to NOC from Income Tax Department. Himanshu has asked. So I'll just clarify, because this question keeps on coming to all of us as a liquidator also. I am aware about that. The Income Tax Department has issued a clarification, and even IBBI has issued a clarification further in this particular regard, that no objection certificate is required in respect of voluntary liquidation process. But I agree, when you go to adjudicating authority is asking. And I will say only one thing, that it's a matter of education. That already IBBI is doing a lot of education program for the Income Tax Department. But because of lack of awareness, lack of education, they have been insisting, and so is the case with all due respect to the members of judiciary also, that they might not be completely familiar or aware with regard to the particular change what has been brought. So I'll say that whenever you are appearing before the concerned member, you can provide the copy of circular. Maybe in certain cases, they just want a confirmation from the particular person who is the liquidator, to confirm that there are no dues which are pending in respect of any of these statutory authorities. Because this is a
Amitji, I think the question was relating to foreign remittances. So AD Bank, unless there is something from RBI, AD banks will continue to ask for NOC for foreign remittances.
I'm sorry. Okay.
Friends, thank you very much, Amitji. It was, I personally am really grateful to you, in spite of your such busy schedule and putting you in such an inconvenient position that you're sitting at the airport and talking to us and sharing your wisdom with us. Thank you very much for your benevolence. Friends, thank you very much, Ankit. All the changes we discussed today, friends, are landmark. They are very important for all professionals. The changes in company law will open many new vistas. It is for professionals to explore those vistas and educate the companies. on these new provisions. And also, I am very sure that all these changes which have been made in the liquidation process will result in faster liquidation. Thank you very much, all of you. Friends, our journey of knowledge sharing will continue. As I announced in the beginning also, our next webinar will be held on Friday the 15th, because 8th of is Shivratri, is a holiday. So 15th we'll meet again, and we have chosen a very important topic, that is human resource restructuring in the light of the new labor codes. And we will have very elite faculty for this particular webinar. Mr. Anupam Malik and Mr. Zorawar Singh, who is a renowned HR expert. They have very kindly agreed to address and interact with the participants. Thank you very much, one and all, and look forward to your support and look forward to your participation in the coming webinars. Thank you very much.